Welcome to this second edition of our seminar on human rights and natural resources. My name is Richard Mear and I'm the joint head of the International Relations Department at Leigh. And we're really delighted to be hosting this event in conjunction with King's College Transnational Law Centre. We've got Octavio Perez from the International Law Centre there, and Clean Trade, and we've got a number of people from Clean Trade here, including the founder, Leigh at the back there, and others of us who are trustees of that group. And as I said, it's the second time we've done this. Last year, it was a similar kind of event, but different subject matter and different speakers, but very similar themes. So today we've got three sessions. The first is on the impact of mining and agribusiness on indigenous rights. And I think we'll probably go through to about 11:30 on that because we started late, if that's all right. And then we've got a break and then a session on natural resources, extractives and sustainable development. And then after lunch, the final session on supply chains, climate change and ESG. And just to kind of flag up, I think, a few of the key issues that I think are going to arise today. Obviously, we're looking at particularly the impact on indigenous peoples of natural resource activities on human rights and environment. And that's not just generally, but I think specifically in relation to activities which affect climate. So in both directions, actually. Deforestation, which obviously has a negative effect on climate, but also activities like cobalt and nickel mining, which the objective of which is to improve global warming, but has, as we'll hear, some negative impacts on indigenous people. And then we're going to be looking at, I think, the issues around justice and accountability for people whose rights and environment are adversely impacted, whether that's civil damages claims or complaints under various mechanisms, including to UN committees on cultural, economic and social rights, for instance. And ESG, how businesses which make ESG commitments and make commitments, for instance, under the UN guiding principles on business rights, how they can be made to adhere to those, and that would include actions against governments, but also potentially shareholder actions as well. And then I think the other thing that will probably emerge during the discussion is the tension that exists between the right of peoples to use their resources freely on the one hand, and sustainability in particular when it comes to climate on the other. So I think those are some of the key themes, but I think we should kick off the session, and we're going to start with Octavio Perez, who is a professor of law and the co-director of the Transnational Law Institute at King's College London, where he leads several research projects on the role of law and courts on addressing poverty, inequality, environmental harm and human rights. And as well as his academic work, he's a consultant and practitioner in the areas of human rights and environmental law with a special focus on Brazil. So, Octavio, I'll hand over to you.
Thank you, Richard. Hello, everyone. Good morning. It's a pleasure to be here. Thanks, Johnny, for organizing this, and all the other people involved, Katarina, Leigh from Clean Trade, Andy is there at the back. I'm going to kick off talking about the impact of mining. I'll leave to Johnny because his case is focused solely on mining. I have work on mining as well. If you want to ask in the Q&A, feel free to do so. But I wanted to focus on agribusiness in my 15 minutes that I have today. So just a few basic facts about the Amazon. First, is the largest tropical forest in the world, and as such, quite important for climate change, not only regionally in Brazil and also America as a whole, but also globally. If the Amazon goes, I think we would all be affected. And the sad fact is that it is going. It is being destroyed. We have now, studies vary, but between 20 to 25% of the Amazon forest is already gone. I have a slide, my only slide is that one. So this is the Amazon in Brazil, which is where I focus. It's also in another 9 countries, 9 including Brazil. And here, the green is the forest which is still there. And that kind of orangey bit is what has already been deforested. And it's going increasingly into the heart of the Amazon now, the deforestation. I've been to the Amazon several times in my research projects, and you see it when you go down the river or when you drive like on one of the motorways that the military government opened there in the 60s and 70s. You see more and more just raised ground and cattle and soybeans, which is what I'm going to talk about today. So it's really serious, the situation. Some people believe that there is a turning point that we are approaching. So it's not about getting rid of 50%, 60, 70 of the Amazon. Once 30%, according to some studies, go, then it starts to not be capable of regenerating itself, and it collapses and becomes a savanna kind of biome, and not like a tropical forest anymore. So it's really critical, the situation, and it has become worse during the past government, the Bolsonaro government, which was openly for deforestation and agribusiness. And now it's a bit better, but we cannot rest and be complacent thinking, the new government is in favor of the Amazon and therefore it's going to be preserved now. Because the forces that are already there, quite deep into the forest, the local political leaders, they are all for cutting the trees and putting cattle and soy or mining gold in the Amazon. So it's really critical that all of those who wants to keep the forest standing continue the fight and actually intensify the fight, because even if now, like Lula was really proud, and I think rightly so, that in his first 7 months of government, deforestation went down by 70%, but there's still 30% of deforestation going on there. And we should be stopping deforestation. It should be zero now, and should start thinking about reforesting the Amazon. There are really interesting scientific plans for like recovering the degraded areas, but it's still going on, like deforestation is still happening. Now, what drives deforestation? It's basically 4 things. Cattle farming, which is the worst and the largest amounts of deforested areas that to put cattle there so that people can eat their barbecues, churrasco. And Lula is really proud that he made the poor people able to eat meat. So there's a kind of a contradiction there, but it's hard like to solve it because you want the poor people to eat meat like the rich do. But if everyone eats meat, then the Amazon is going to be the place where you raise the cattle. So cattle, logging, mining, and agriculture, agribusiness. And I'm going to focus on agribusiness today. Agribusiness has exploded in the Amazon. And now, as I was talking to Richard just before we started, the Brazilian Congress is dominated by right-wing members of parliament, and 70% of those are backed by agribusiness interests. So they finance the election of these guys, and there is no surprise that the laws that are coming out of Congress now put more pressure on the Amazon want to open up indigenous people's lands, one of the topics today, for mining and agribusiness, and therefore is going against what we need to be doing, which is stop deforestation. But now, who are the culprits? So what causes deforestation are these four activities, but who are behind them? So there are a great deal of just adventurous individuals who moved from the south of Brazil up north when the military dictatorship was incentivizing that kind of migration and saying, look, it's a land without owners. We want to turn it into owners with land in the Amazon. They completely ignore, obviously, that indigenous peoples had been there for thousands of years and preserving the forest. So there are lots of these individuals who got established there, small and medium farms, but there is also big companies. And this is where I think one of the most important issues are and where we should be doing more, and they does a lot on that already, obviously, but I think we can do more. And one of the companies that have been quite critical in deforestation in the Amazon, which I want to focus today, is Cargill, which is one of the largest, I think the largest company in the world, and who has built 2 ports on the Tapajós River, one of the main rivers that goes down in the Amazon, to export soy from the Amazon. And this has led to a growth in deforestation, which, if you go down that river, like, or the roads there, like I did last year, you can see that it's shocking how much forest was lost to the monoculture of soy, which not only destroys biodiversity, makes climate change worse, but also creates lots of problems for the rightful owners of those lands, the indigenous groups, and not just indigenous groups, because there's this misconception that in the Amazon there were only indigenous groups, but there are other traditional communities living there of riverine peoples and quilombolas, which are former enslaved people who fled there quite early on in the colonial times of the Portuguese, and are well established there. And these 3 groups are the groups that live off the forest without destroying it. So that's scientifically proven already. If you go into these lands, it's about 4% deforestation for small farming, subsistence farming. And if you move outside of these lands, then sometimes 70, 80% of the forest is already gone. So if you want to defend the forest, one great easy way of doing so is defend the lands of those people, but this is increasingly under pressure by the agribusiness interest, which is fueled by these huge companies that export the produce of like cattle and soy here to the UK, to Europe, to America. So we are consuming the Amazon ourselves. When you buy a chicken burger in Asda, our friends from Mighty Earth have a great report on that. You are actually eating soy that was produced in the Amazon, exported through the ports of Cargill to the plants here in the UK to feed chicken and pork, and then sell these burgers in the supermarket for us ourselves to eat. So it's really important to reveal these connections between the big companies that say, well, we are only buying the produce, we are not causing the destruction, but they actually are. Indirectly, they are. So just to give you a couple of data that I commissioned for a research we are doing about deforestation in 3 municipalities of Pará, where Cargill works. We, from 2000, which is before Cargill built its ports in the Amazon, to 2022, there were 280,000 hectares, almost twice the municipality of Rio de Janeiro or if you want in London terms, it's about 1.5 Londons was deforested in that region just to produce soy to be exported through the ports of Cargill. So it's quite a lot of destruction. Now, it's a very complex situation. What is the causation here? I think there is a before and after Cargill, which is quite clear. Before it was all forests and small farms of subsistence doing fruits and vegetables. Now it's like soy, and even bigger farms. The small farmers are being kicked out, often with violence, often with threats by bigger farmers. And before, as I said, that didn't exist. And now a final point from a research project we've just started and published a few days ago, a piece in Sumauma, which is one of the leading environmental news platforms in the internet, a joint venture between Jonathan Watts, the global editor of The Guardian for the environment, and Eliane Brum, a Brazilian journalist based in the Amazon. So Sumauma, we have a partnership now, King's College and them, to go there and reveal more of these connections. Cargill is planning a third port in that region, in Santarém. And we know already what happened with the two ports that they've built, so a third one would be disastrous. And to make things worse, there is a suspicion now that the land that they acquired to build this port was acquired irregularly from riverine communities who had the right to that land through like third-party people who didn't have the right to buy it. So it's a mess now. And the Brazilian prosecution service, the Ministério Público, is now investigating to see whether they can annul the sale of that land to Cargill to stop the port being constructed. So this is my cue that I finished my time. This is just like a small, really, sample of what is happening in the Amazon at the moment, and I'm happy to answer any questions if you have them. Thank you.
I think maybe what we can do is leave the questions till the end, after everyone has spoken, and deal with it in that way. Johnny Buckley is the next presenter. Johnny is a senior associate in the International Group Litigation Department here at Leigh, and he has been running cases for the past decade now, I think, against mining companies operating in South Africa, occupational disease and environmental cases, and also more recently the Kabwe lead mining case in Zambia, which we spoke about last year. We're not going to talk about it this year, but Johnny, I'll hand over to you.
Thanks, Richard. Today I'm going to talk about a case in which we are currently acting for indigenous Quilombola communities in Bahia, Brazil. The case involves an iron ore mine in Bahia State, owned by a company called Brazil Iron Limited. It's a UK registered company with a Brazilian subsidiary, Brazil Iron Mineração Limitada. And the mine is located near the city of Piatã in the center of Bahia State, about 600 kilometers west of Salvador. There are 150 families that reside in the indigenous Quilombola communities of Moko and Bocaina, and you can see how close they are to the mine there, especially Moko. And the communities complain that this mine has been polluting the surrounding villages for a number of years now, but particularly since 2019. As I mentioned, these clients are from indigenous Quilombola communities. Historically, Quilombola communities are amongst the poorest in Brazil, and many of the clients are subsistence farmers or they're reliant on social welfare programs such as the Bolsa Familia, which is a federal government grant. In 2013, the Palmares Cultural Foundation, which is a public institution attached to the Brazilian Ministry of Culture, granted certification to 4 sub-communities in Bocaina as quilombola communities. The vulnerability of these communities attracts special protection under the ILO Convention, namely a right to free, prior and informed consultation in relation to the use of their lands, territories and resources. And there are also protections for quilombola, I don't know what's happening, sorry. Quilombola communities under the Brazilian Constitution and Brazilian federal laws, such as respect for the demarcation of land belonging to quilombola communities and historical sites, and protection of the cultural expression of quilombolas. Another protection is the observation of administrative procedures in the environmental licensing processes for works, activities or undertakings that impact quilombola lands. Notably, I'm sorry about this, I don't know what it's doing. Just put it down. Notably requiring the preparation of impact studies specific to quilombola communities, such as the Quilombola Component Study and the Quilombola Basic Environmental Plan. Another protection is that it requires participation by a number of institutions, the National Institute of Colonization and Agrarian Reform, INCRA, the Palmares Cultural Foundation and the State Secretariat for the Promotion of Racial Equality before mining authorizations are issued by the National Mining Agency and the environmental regulator, INEMA. In this particular case, Brazil Iron failed to inform the environmental regulator, INEMA, about the existence of a quilombola community when it applied to INEMA in 2013, requesting 2 environmental permits to mine on the land. The failure to refer to the existence of a quilombola community at the site of the mine's installation resulted in the residents being deprived of some of the fundamental rights that I've just described, such as FPIC and the preparation of the impact assessment specific to quilombola communities. I'm going to talk a little bit about some of the specific complaints being alleged by our clients. And you can see in this picture just how close some of the residences are to the mine, just a matter of 100 or so meters. Dust pollution or pollution in the air is one of the complaints. The mine operations generate significant iron ore dust pollution containing toxic metals, both in the air. Sorry, this is a video, by the way. Shoot. There you go. In the air and covering objects in the client's houses. The dust also covers crops in our client's fields and contaminates the soil. And you can see in this video an example of pollution in the air after blasting at the mine. Another complaint is contamination of soil and crops. Land and crops belonging to our clients has been covered in iron ore dust. In addition, water sources belonging to our clients have dried up after becoming contaminated with iron ore waste, causing crops to stop growing. The effect on some clients has been compounded in that they're unable to produce as many crops as before, and what they can produce is contaminated with iron ore dust. Another complaint is water pollution. Our clients' water sources, including wells, springs and groundwater, have been polluted, including by the mine waste being dumped into the Moko Dam, which is what you can see on the photo on the right there. And this is also a video on the left. Some clients have reported sludge-like muddy water appearing in their water sources, an example of which is in that video. The next complaint is property damage. Many of the houses in Bokaina and Moko are constructed with mud bricks and local materials. Explosions from the mine have caused significant structural cracks in the homes of our clients. And although the mine has agreed to fix some of the houses closest to the mine, the majority of damaged houses remain unrepaired, and our clients have received no assistance from the mine to repair them. Our clients also report noise pollution generated by machinery from the mine, such as jackhammers, truck traffic, sirens, and explosions from rock blasts, even overnight and during the early hours of the morning. Many clients have had difficulty sleeping and anxiety-related concerns, particularly during the most recent period of increased activity by the mine after 2019. The dust pollution has also allegedly caused physical injuries to some of our clients, such as respiratory injury, rhinitis, sinusitis, coughing, sore throats. And our clients are also alleging psychological injuries, some of them caused by the excessive noise pollution emanating from the mine, including disturbed sleep patterns, anxiety, depression, and stress. A number of clients that own land also complain of incursions onto their territory by the mine, seizing, drilling, or exploring on their land without permission or without compensation. One client reported to us that the mine had not only encroached on his land, but fenced off the access road as part of the mine operations, so there was no way to reach his land except via the natural terrain. But I'm going to talk a little bit about Brazilian law because it's quite interesting in this case. Brazilian law will apply to this claim under the Rome II regulation, which was retained law after Brexit. So it still applies, and it says that the applicable law to the claim is the law of the place where the damage was sustained. So Brazilian law will apply here. Brazilian environmental law is fairly progressive and we think favourable to the claimants. For example, under the Brazilian Civil Code and the National Environmental Policy Act of Brazil, it can be argued that Brazil Iron is strictly liable as an indirect polluter and is therefore under an obligation to repair the damage regardless of fault. There was a landmark decision in 2007 by the Brazilian Superior Court of Justice, where Justice Herman Benjamin ruled that an indirect polluter can include persons with ultimate ownership and or control of the entity directly responsible for the damage, failure to supervise an activity which led to the damage, funding an activity of others that led to the damage, and or benefiting from the activity of others that led to the damage. So you can see that that definition is quite wide, and we think wide enough to include the parent company's responsibility for the actions of its subsidiary. We're also arguing two other causes of action under Brazilian law. One, that Brazil Iron is liable under the Brazilian Civil Code for the damage caused by negligent acts and omissions, not just by them but by its subsidiary. And also that Brazil Iron is liable under the limited liability company law as the controlling shareholder of the Brazilian subsidiary. There are also a number of state and federal laws that have been breached by Brazil Iron, and I alluded to some of them before, but they mainly relate to the constitutional laws that protect the land of the Quilombola communities. Access to justice is also an important consideration in this case, as it is open to Brazil Iron to challenge the jurisdiction of the UK court to hear this claim and argue that Brazil is the more appropriate forum. However, in this case, we think that there are strong arguments against that. In general terms, in Brazil, it appears that while access to justice varies from state to state, Bahia appears to be one of the worst states for access to justice. In particular, this community's remote rural location and lack of financial resources and lack of faith in the state institutions make it even more difficult for them to obtain justice in this case. There are also issues of delay and lack of resources in the Bahian courts in terms of both bringing cases and implementing decisions. In addition, the Bahia state government and judiciary is known to have issues with corruption, particularly on environmental matters. There have been recent news articles uncovering a bribery scheme for the awarding of environmental licenses in the state, and a recent federal police investigation into alleged corruption on the part of judges, lawyers and farmers into securing favourable rulings to legitimise land grabbing from local communities for agribusiness. From our conversations with the community members and the leaders of the community, it's evident that this community has struggled for several years to have their complaints about the mine heard. The company is closely allied with the mayor and the municipality of Piatã, as well as the environmental regulator INEMA and other state institutions who view their operations as beneficial for the economy of the area. The mine has regularly breached the conditions of its mining authorizations, which has led to periods of suspension in its operations. But then the authorizations are renewed when the mine promises to implement remedial measures that are, according to our clients, not actually adequately implemented. Furthermore, for a number of years, the company has engaged in a campaign of intimidation and pressure, putting many community members and leaders from the community association under great pressure in order to try to prevent them from publicising their grievances against the mine. Just in terms of where we're at with the case at the moment, we notified Brazil Iron in the UK of the claims of 80 of our clients in early September. And normally under the UK civil procedure rules, that's known as the pre-action protocol period, where it's supposed to give the parties an opportunity to explore whether the claims can be resolved without issuing court proceedings. But there was no engagement from Brazil Iron in response to our letters, and instead they sent their representatives in Brazil around to our clients' houses to try to coerce them into withdrawing their claims against Brazil Iron in the UK. So given the unacceptable harassment and intimidation of our clients and the fact that Brazil Iron has not engaged with us as the client's lawyers, in response to the letter of claim, we went ahead and issued the claims in court about a week ago. So watch this space for further developments.
Now going to hand over to Fiona Watson. Fiona is the Research and Advocacy Director at Survival International and been there for over 30 years. Well, that's almost as long as I've been here. And you've worked on many campaigns for indigenous people's rights in Brazil, in Botswana, Latin America. You're a specialist on uncontacted tribes in the Amazon. So, over to you, Fiona.
Thank you. So I'm going to talk about a new case of survivals in Indonesia with an uncontacted people called the Hongana Manyawa. And it's basically about how nickel mining stands to devastate, if not wipe out, the Hongana Manyawa. And this is all for electric vehicle batteries, which, as you know, everybody is talking about, and there's a lot of greenwashing. So first of all, the Hongana Manyawa number about 300 to 500 people, which actually in terms of uncontacted indigenous peoples anywhere in the world is actually a very significant number. And we only really became aware of them a few years ago. So it's a very interesting case. Around the world, generally, there are over 100 uncontacted indigenous peoples or tribes, the vast majority in Brazil, but also in Paraguay, Peru, Colombia, also India in the Andaman Islands, several islands there. And Survival has, for many years, been campaigning for their rights at a global level and in these various countries. And they do, as I will explain, have rights, certainly under international law. And for those who are not really aware of uncontacted indigenous peoples or tribes, we define them as being people who reject contact with national society and often with neighbouring tribes. They may be related to them. So, for example, in Brazil, many uncontacted peoples, we think, had some form of contact with neighbouring indigenous peoples several hundred years ago, but for various reasons, with colonisation, land theft, the rubber boom, they retreated up the headwaters of the Amazon to escape atrocities, enslavement in the rubber boom. Sometimes these people are referred to as people living in voluntary isolation, and that is the case under the UN and I think the OAS Declaration on the Rights of Indigenous Peoples. We use the phrase uncontacted because voluntary isolation does imply a degree of choice, and we feel that in many cases they're being forced to adopt a position of isolation in order to survive. And historical memory has taught them that it's the only way they're going to survive disease and violence. And actually, a recent UN report said for these peoples, isolation has not been a voluntary decision, but a strategy for survival. So forced contact kills, and there have been many, many cases of this. In 1984, over 50% of the Nahua people in Peru, uncontacted people, died following the effects of contact. And that started because Shell was prospecting in the Amazon in Peru, and they built lots of seismic trails. And then after their activities finished, these trails were used by loggers going in. And disease is probably the single biggest killer of any uncontacted people, because by virtue of the fact they've been in isolation for so long, they have no immunity against common diseases like flu, things that wouldn't affect us. And there are many, many examples of these genocides. A lot has been documented in Brazil, which, as Octavio mentioned, the Amazon was opened up, particularly under the military dictatorship. And these people were simply, literally, in some cases, whole communities were bulldozed as they were building, the military building these huge highways to open up the Amazon. So just to give you an example, the Suruí people who live in the Western Amazon were contacted in the 80s. 75% of them died from measles and TB in just 6 years. So actually many peoples, indigenous peoples we see today in the Amazon are still surviving, living with those initial impacts, huge population loss because of contact. And when we spoke with the Hongana Maniawa, those who were contacted, because I should say some of the Hongana Maniawa are contacted, they remembered their first contact and they called it a plague, where many people died and then others fled back into the forest, opting to be uncontacted as a survival strategy. So I'm talking about a mine down in Wedder Bay Nickel, which is the company that's processing the nickel. And so this is all Hongana Maniawa land. So this is in the south of Halmahera Island, which is in the northern part of Indonesia, just west of the island of New Guinea, west of West Papua. So this was it in 2016. This is 2019, and this is 2022. So you can see from the satellite images that this is an enormous project. Just in 6 years, it's at least tripled in scale. And this is an industrial park owned by the Indonesian company, Wedder Bay Nickel. And it's processing all the nickel that's coming from the island, from all the mining companies who are prospecting there. And we are focusing particularly on a French company called Eramet, because they have concessions where the uncontacted Hongana Maniawa live. And they have partnered with a Chinese company called Tsingshan, and this is going to be the world's largest nickel mine. It's also the largest cobalt mine outside the Democratic Republic of Congo. The French government have a 25.7% stake in Eramet through a public investment bank. So Eramet are one of our main targets. Wedder Bay Nickel has a very bad environmental record, needless to say, and in 2021 they were found guilty of at least 25 counts of environmental mismanagement by the Indonesian Environment Ministry, including excess levels of zinc and ammonia in rivers. And in 2023, the Indonesian ministry issued them with what they call a red report, which is the worst kind of report warning that they can issue for their poor environmental standards last year. Another player in this is BASF, the large German chemical company, which some of you may know was responsible, has a notorious past because it manufactured Zyklon B, the gas used by the Nazis in the concentration camps. And it wants to partner with Eramet to process the nickel from Halmahera Island. And so the ultimate aim of the project is to make electric car batteries. And so partnering with a mining company such as Eramet, and Eramet knows, I'm going to explain in a minute, that there are uncontacted Hongana Maniawa there. So BASF partnering with a company that knows that there are uncontacted people at huge risk is laying BASF open, obviously, to be complicit in a potential genocide if these people are wiped out. And then looking at the various laws and how Eramet and BASF are in violation of, in this case, French and German law, because they're French and German companies. So they are knowingly operating on territories of indigenous peoples without their free, prior and informed consent. And Eramet is in violation of a French law from 2017, the due diligence law, and which mandates companies to include the reasonable vigilance measures to allow for risk identification and for the prevention of severe violations of human rights and fundamental freedoms. And similarly, BASF, which is partnering with Eramet, is in violation of a German law which came out this year in 2023, the Supply Chain Act, which I'm sure a lot of you are aware of. And this says the prohibition of unlawful eviction and the prohibition of unlawful deprivation of land, forests and waters in the acquisition, development or other use of land, forests and waters, the use of which secures a person's livelihood. So one can argue very strongly that using this, both the French and German, these two laws, these companies are in violation of the rights of the uncontacted and contacted Hongana Maniawa. So moving on to Indonesian law, unfortunately, the Hongana Maniawa have not been recognised as an indigenous people by the government, and their territory hasn't been mapped. So really, we're kind of starting from scratch. This is quite an uphill task. But there is this historic Indonesian Constitutional Court decision that confirms that the status of customary forests, that is the forests used by indigenous peoples and forest peoples, belongs to indigenous communities. So one can say that because of this Constitutional Court ruling, the Hongana Maniawa are entitled to decide who use their forests. They are the owners of the forests and should be recognised as such. And so now the urgency is for the territory to be mapped out. Moving on to the electric car companies, there are quite a lot of them poised to invest in Indonesia, and the government is promoting massively, wanting to sell the nickel for the electric car companies. And this, of course, comes at the expense of indigenous peoples like the Hongana Maniawa and the forests. And the mining companies are in their supply chains. So, of course, there's a massive amount of greenwashing going on. And as you're probably all aware, that this huge drive by many companies to invest in electric car batteries is being touted as green and the big alternative to fossil fuels. But it is not green at all. So for an example, it takes 19 tonnes of carbon to smelt 1 tonne of nickel and almost 2 tonnes of toxic waste for every tonne of ore processed. So that's around 50 kilograms of waste per electric car. So this is a massive price to pay, not only for the Hongana Manyawa and other peoples like them, but also for the environment. So it's hardly a green alternative. So more and more forest is being destroyed, and the people who defend it. And of course, in terms of climate change, we should be supporting, as Octavio mentioned, all the environmental scientific studies coming out, particularly out of the Amazon from Brazil, is that indigenous peoples are the best protectors of the forest. So if you want to save forests around the world, wherever they are, you should be investing in indigenous peoples and supporting them in the defence of their territories, the mapping of their territories and the protection of their territories. It's an absolute no-brainer. But of course, commercial interests don't always see it like that. So how do we know about evidence of uncontacted peoples? Well, actually, there is evidence, and quite a lot of it. So these various photos here show you can see evidence of their houses. Occasionally, they may be spotted, like in the bottom right. That comes from a video of an uncontacted Hongana Manyawa person. We hear anecdotal stories from their contacted relatives who often know exactly where they are and who may have sporadic contact with them, doing aerial flights, walking in the forest, seeing signs of people. There's been a lot done in Brazil, actually, on how you amass evidence. And so this, for example, was filmed last year. And it's very clear they don't want contact. This is an uncontacted Hongana man. And this is what the Hongana Manyawa, who have told us, my colleagues who've gone out there to talk with them about it, very, very clear. If we don't support the fight for the forest, my uncontacted relatives will just die. The forest is everything. It is their heart and life. My parents and siblings are in the forest, and without support, they will die. Everything in the forest is getting destroyed now. The river, the animals, it's gone. And this is so important because indigenous peoples, as I'm sure you know, have an extraordinary spiritual relationship with their forests, or any land. It doesn't have to be forest, desert, whatever. So the forest to them is, in many ways, is completely different to how we might look at a forest. So it's not just their livelihood, it's actually these very important connections. It's their spirituality, their cosmology, their vision of the world, and this incredible scientific knowledge. I mean, these peoples are scientists. And the more that scientists are working in ethnobotany, ethnomedicine, it is patently obvious that these peoples have this extraordinary knowledge. And so all of this stands to be trashed in this drive for nickel and electric car batteries. And then this Eramet, the French company, mining company, commissioned a consultancy called Cross-Cultural Consultancy to do an impact assessment. And they mapped out the territories so they know the uncontacted people are there. They hid this report and we got hold of it. It was done in 2013. So they have known for years that uncontacted peoples are there. And the different colours, the green, the yellow and the pink, there are uncontacted Hongana Manyawa in all these areas. And in the pink on the bottom right, there are only uncontacted people there. And if you look at the south where the sea is, that's where the Wedder Bay nickel mine is that I showed you those satellite images. So they are incredibly near all this activity. So moving on to the question of consent, and I'll be quite interested to know from all the lawyers here, because I'm not a lawyer, about how do you get consent, or how do you get even permission to act for uncontacted peoples if you were to take it as a case? So the contacted Hongana Manyawa say they will never give the company consent to use our lands. And Wedder Bay Nickel and Eramet are on a drive to coerce, to force people to give consent, and the Indonesian police. So they're really trying, but they're going to stand firm on this. But of course, free, prior and informed consent cannot be given by uncontacted peoples because you can't contact them, you cannot consult them. And there are a number of rulings or things like the Inter-American Commission on Human Rights and the UN Special Rapporteur recognise forced contact as a grave risk for uncontacted people's lives. So if the company, like Eramet, is trying to force contact, and there are signs that they are, this violates these people's rights under international law. So here, the right to self-determination, the right to life, the right to health. And it also violates ILO 169, which Indonesia hasn't ratified, but looking at, as best practice and the best international norms that exist, it's in violation of all these, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, and on the International Committee for on the elimination of racial discrimination. And interestingly, IRMA, which is an initiative for responsible mining assurance, has a very strong policy on the rights of uncontacted tribes. And it's very clear, because of the requirement that FPIC be free from external manipulation, coercion and intimidation, an FPIC process cannot be undertaken in situations where indigenous or tribal peoples are living in voluntary isolation, which is the same as being uncontacted. Consequently, IRMA will not certify mine if affected communities include indigenous peoples living in voluntary isolation. So that's very important and useful because many mining companies are trying to get IRMA certification for their operations. And there is, as I mentioned, talking about international standards, Brazil is the country that has the most uncontacted indigenous peoples, and also the only country in the world that has a whole department dedicated to uncontacted and recently contacted indigenous people. So they have a huge amount of experience, which is extremely important for people like us in trying to lobby these companies and the Indonesian government. We can look at precedents in Brazil where, for example, the minute they suspect there is an uncontacted indigenous people in an area, they have these things called restrição de uso, which is a land protection order, which they can slap on a territory, which means nobody can go into that territory until all the process of working out where the uncontacted live, how many they are, what land they're occupying, and then mapping it and recognising their rights. So this is very useful and important. So what we are calling for is no mining or processing or any other developments without FPIC, which by default means no mining at all, because we're talking about uncontacted peoples who cannot give their FPIC. Survival is trying to, we are talking to various electric vehicle companies and getting them to sign up to pledge not to buy materials from the territories of uncontacted people, tribes, and they're therefore stopping the supply chains from operating there. And then we are lobbying the Indonesian government to set up a sort of no-go zone or a buffer zone around where the uncontacted Hongana Manyawa live to protect them. And the campaign was launched earlier this year. And these are some of the conditions. We are talking with Eramet and BASF, both of which are poised to sign agreements. They haven't done that yet, so we're trying to impress on them just how urgent this is. And we're doing various campaigning, emailing campaigns, all sorts of things. And I think that's it. Yeah.
Thanks, Fiona. I'm sure there'll be lots of discussion about this at the end. What a food for thought there. Thanks. Next, our final speaker on this session is Jeremy Gilbert. He's a professor of human rights and a special advisor with Clean Trade. And his main expertise is on the interaction between international human rights law, the protection of the environment, and the emerging rights of nature. And Jeremy regularly serves as a consultant for several international organisations, notably the UN, and is a board member of the People's Planet Project and the International Lawyers Project. Thanks, Jeremy.
Okay. So, morning everybody. Hope you still have some energy. Maybe 2 disclaimers about me before I start. You can hear I'm a bit croaky. You don't have to run away. There's no COVID. I did 2 tests. I just have a bad energy, so you can speak to me after this. But also, what happens when I'm like this, my French accent is even stronger. So if you feel like I'm talking French, you can wave at me and I will put the subtitles. I'm going to talk about this case, but actually I'm going to talk about the issue that you mentioned, Fiona. Yeah, my job is really, it's between international law and making this bite into the court. Because you can see there's a lot of international law, but as we know, how do we make this work into a legal process is the big question. So I've done a lot of cases which at the Inter-American Court of Human Rights, the regional system of human rights, basically, where the case is really against the states, but we know that companies are behind, because that's the other problem with human rights law. It doesn't really bite onto the companies yet. You might know there's a treaty in for the last 10 years, but we're not yet in that situation. So really, my relationship has been with the communities to help them. Because, they know they have international law, but how does that actually react? Or do you push that into a legal system is very difficult, but also, how do you convince the lawyers to use international law? So there's a bit of translation, I think, in terms of international law and the way it relates to the law in the country, but also what it relates to indigenous peoples, what they want from that. So this is why people like me are useful in this, because we act between the lawyers, the communities, and try to serve as translators or evidence gatherers of this and bring it to the court. So I'm going to talk both about this case, but use this case as a way to be critical of international human rights law and where we got to with those cases, the limitation of those cases, but also the beauty of it. And the way it could relate to some of the cases you mentioned, Fiona, but also the case in Brazil. So hope I'm not going to lose you in international law, but just try to keep in mind, I'm coming from the international law angle and try to see, but does it actually work on the ground? But also, does it represent the interest on the indigenous communities? Because this legal language is often made in Geneva or New York, which is not often what indigenous peoples might want. So I'm going to go into the right of nature. So that case, the Uwa community are about 8,000. It's we don't have exact figure, but we're talking about 8,000 people basically in the forest region in Colombia, in Brazil. How did they get involved in international human rights litigation? Started 25 years ago when oil was found on their land. So we're going to look at oil exploration. The company behind is Occidental Petroleum, which is a US company, but actually operates through a national petrol company in Colombia. So that makes it very difficult to go after the private actors because it's basically run by the government in a way. So they found oil anyway on their land 25 years ago. Exploration started, the government gave the right to exploit the oil, to extract it. There was absolutely no consultation whatsoever. Everything we talked about wasn't done to the communities. Even though it's clear that they live there forever, it's their land, there's no doubt about that. They still live close to the extraction. So what the community did first was to organize both protests. And you might remember in Colombia 25 years ago, so the situation was very difficult politically, but also in terms of paramilitaries operating, etc. So they went nonetheless for a campaign of public advocacy to raise the case. There was public protest. They did try to physically stop some of the extraction, but that didn't land it right because harassment, violence was really prevalent. Then because of change of government, but also Colombia went into a very good national legal system. So there was a clear transition there. So it was an opportunity for them to start the legal challenge. The legal challenge against the government say no free prior informed consent, no respect of the land rights, no integration of any benefit sharing for the community. We haven't talked about this also, but there's also a benefit rights for the communities when you have free prior informed consent. So all of those rights were not at all on the radar. So they started the long process of litigation. They lost at all levels. So I will spare you the 25 years of litigation. They went from the lower court to the highest ones. The view was at the time the law was different, so therefore you couldn't apply it retroactively, and they kind of lost that way. The argument was international was always there, and the government has ratified those treaties, so the law actually was already there on free, prior, and informed consent and all those protections. They turn to the Inter-American Commission of Human Rights that you mentioned. So one level in the region is to turn to the regional human rights bodies. The first step is a commission, which is not a court, but is an independent body that can make recommendation to the government on the way they should integrate and protect the human rights obligations they ratified. It took a bit of time, and I'm going to be insistent on this. The case was lodged in 1997, and it's only in 2015 that the commission finally, not only your own, but we're going to take your case forward. And in 2019, they've agreed and they made the recommendation to everyone that all the rights were violated from A to Z, basically. So self-determination, right to life, right to property, and etc. Recommendations are important. I don't know how familiar you are with this, but it's a recommendation, as it says. It's not a binding decision yet. The government is supposed to follow up. They did nothing. But there's a mechanism by the Commission where they can trigger the court. So now we're moving to the court, the Inter-American Court of Human Rights. That trigger was done in 2019, and the case since then has been in front of the Inter-American Court of Human Rights. It was heard last May. So you can see they started in 1997. It's been a long journey for the community, and finally the court was there in May in front of the court. The good thing is because it was so long, talking with the committee member, like, yeah, Jeremy, don't worry, it's long, but at the same time, we got better at this. And what they mean by this, the argument they put forward to the court, they feel are much stronger than what they did maybe in front of the commission. So what I mean by this, I'm going to go back to this issue of, what sort of the rights we're talking about. Free, prior, and informed consent is a beautiful made-up right, but actually we need to go into those rights. What do they mean for the communities? And one thing for the community that was clear, like, not only there shouldn't be any mining on our land, but taking blood, we have a spiritual connection to the land, and the oil actually is the blood of Mother Earth. It might sound a bit far from international human rights law, but the argument is for them, just taking oil itself shouldn't be done because you are damaging the spiritual relation with something very important in the relation with the land and the way the creation stories of the communities. This is where most lawyers will go, wow, that's a bit far stretch. But this is where human rights law has evolved a lot. Yes. To say no, actually, and that's connecting to some of the issues we mentioned, the right of nature, so that actually nature might have some right as well into this. So they've asked me to basically put the argument to the court to say, could you help us to tell the court, okay, our right to life has been violated, our right to free, prior, and informed consent has been violated, but also our right to have a spiritual connection to our land has been violated with this. And we want the government to recognize that they can't extract the oil has to stay on the ground because otherwise you're destroying this very important relationship we have with the land. The argument, the hearing were in May, so we put the argument to the court. When I say that, I should say the way to work with those regional bodies, you don't have to be a litigator or the lawyer. You are invited by the court as an expert witness to support the court in their interpretation of the law. So I was invited by the commission to give that piece of evidence to the court. What we hope, and the reason I put Earth Rights, they were working with me on this, and we really hope that it's going to be something that the court will look at, not only at the other rights. Because for the community, it's really important. They're saying we are the guardians of the land, and we want the court to recognize this. They're saying we don't own the land, we are custodians. So there are little change in the law, but for them it was really important to make those points clear. I wished I could tell you the court bought the argument and that's it. We don't know yet. The decision is coming in January. It was meant to be this month, but it's been postponed. I don't know if you know much, but the backlog of international justice is huge as well, so we are taking delays. There should be a decision in January on this, but there are precedents. So we're not starting naively with the committees. We worked with them and we said there was an advisory opinion by the court in 2017 that already made that jump. That says the human rights of indigenous communities are also connected to a spiritual connection to a land, and that spiritual connection itself means that nature itself might have independent rights, autonomous from interest of the humans. So this is where human rights law is starting to join on the right of nature. I don't know how much you're familiar with this, but this is a movement which is growing fast. Yet that nature also has right. And this is something that many indigenous communities have been at the forefront. Like I heard about New Zealand, where the Maoris have really pushed for decolonization of the law on this, and there's been legal personality of a river, of a forest, of a mountain. So it's joining a little bit this movement by saying that nature itself should be protected. Will it work? There was another decision in 2021 by the International Court of Human Rights against Argentina, where they did that. And indigenous communities made the same argument, and they actually won on this. So we feel that there is movement building in that court. What's been important for the community is to feel that they are much more happier with the legal argument that went to the court than the one before, because they feel it's representative of their vision of guardianship. To broaden a bit what's happening, you might know about in Ecuador, there was a referendum 2 months ago, about exactly oil exploration in part of the Amazon. And the referendum was clear that it shouldn't be done. So the oil should be kept on the ground. And again, Ecuador is one of the forefront on the right of nature. It's adopting its constitution. So there is a bit of momentum as well on the, I know it's a question for us to think about, is the next step to say, well, you don't even extract it because it's a violation of international human rights. So we're not quite yet there, but you can see those cases are opening this space for a sort of right of nature that comes under human rights law. Now I'm going to be a bit more critical. It's beautiful on paper, and people like me get excited to work with community like this. It's a very beautiful journey, but I always warn them that even if you win, you lose, and that's something to bear in mind. Those international regional systems are supportive because the judges who are there are people that actually have belief in human rights. So you're going to get some nice decisions. But I've been working with another community in Africa, the Oga community. They won a beautiful case in front of the African Court of Human Rights 3 years ago. 5 years down the line, implementation is close to ground zero. So there is a problematic with using those exciting development with international law, but the biting is lacking there. And I have no way to solve that. I'm sharing with you that are involved in litigation on how we going to make that junction between beautiful crafted decision by those international human rights bodies, but the national courts are not yet integrating this. And I'm going to use the example of what you talk about, Fiona. I work on another case, which is in Mexico. EDF, so it's Electricité de France, which is the largest electric provider in France, but also you might know it in the UK because even the market has gone here. So it's a huge electrical company. They developed one of the largest windmill field in Mexico on the land of indigenous peoples, and they did not zero of these free violation from consent. So I'm going to the law, you mentioned the due diligence law, because in France, there's a due diligence law, which, as you said, should I open this gap to say it includes international law. So if you violate international human rights law, the court should be able to say, so by point about when it becomes real, but what we've been facing, the French judges don't recognize international human rights law. They say that the UN Declaration of Rights of the People doesn't apply to France. It's a violation of the right of the citizen. All the rhetoric of the French government, which is very racist towards the people, is there. So we are facing this difficulty of making the dots to join there. So yeah, I wish I had another slide to say, hey, here's the solution. I don't. But these are the cases that I've been sort of pushing. In terms of what we're thinking about, I think the interest is also to think, if the right of nature gets there, it will totally change the way we think about what the companies can do, not do. It will add a totally different element. Is it totally insane to think about this? In the UK, I don't know if you heard, there's a movement for the right of rivers. There's been 3 local councils that made declaration. In Spain, last year, there was a parliament decision on the Barmena, which is to protect an ecosystem that requires legal personality of a legal system. So in the last 3-4 years, what we saw is an expansion of this idea. It might be something interesting to bring in there, in that discussion. So I think I've covered most of the idea I wanted to share with you. I hope it makes sense, and I'm happy to talk about the other cases, but yeah, in all those cases, this is what we try to do. I've been working in Namibia as well. There's the same elements of push there. So I hope in the UK there will be soon a case on the right of nature. Thank you.
Thanks very much.